Trying to adjust the lighting without.
That works.
That's better.
No. That's good.
How's that?
That's good. Everybody good with that?
Yes.
So thank you, Kathy, and you sort of have a lot to cover. As Kathy mentioned, there is a handout, and the handout is entitled Terminology and Frequently Asked Questions. A lot of what's in there we will cover as part of the presentation. There's certain things that probably won't be covered, but we'd be happy after the presentation to answer any questions that you may have, and depending upon the question, actually any one of the 5 of us may be in a position to answer that question depending upon the scope of the question. So again, our sort of topic is affordable housing in New Jersey and how it affects Morris Township. And we are going to go through a little bit of a history lesson because Mount Laurel in New Jersey goes back now close to 45 years. And I think it will provide a appropriate framework for you to understand the evolution of affordable housing in the state and how municipalities, including Morris Township, have basically dealt with and addressed the affordable housing issue. So essentially, and we're referring to this as why does Morris have to provide affordable housing, and I'll refer to it as sort of part 1, if you will, and you're going to see a part 2 come up in a bit. So back in 1975, there was a court case. That court case was entitled Southern Burlington County NAACP versus Mount Laurel. And the court basically found in that case in 1975 that every municipality in the state of New Jersey was required through its land use regulations and zoning to basically make realistically possible an appropriate variety and choice of housing. And basically the court ruled that local zoning laws that excluded low-income families, referred to as exclusionary zoning, were deemed to violate the state constitution. And just to give you some indication of what exclusionary zoning practices cited, and there were a number of types of exclusionary practices cited by the court. Single-family zoning on very large lots, 5 and 10 acre zoning was deemed to be exclusionary. Municipalities that didn't zone for any multifamily housing deemed to be exclusionary. Municipalities that sort of overzoned for non-residential development deemed to be potentially exclusionary. In addition, the court found that all municipalities in the state have to plan, zone for, and take affirmative action to provide realistic opportunities for their fair share of the region's need for affordable, low, and moderate income households. This is commonly referred as the Mount Laurel 1 decision back in 1985. So we're going to divert a little bit before we get into the history because I'm sure people want to know what is affordable housing, what qualifies for affordable housing. So essentially, an affordable housing unit has a sales price or a rent within the means of what's defined as either very low, low, or moderate income households. And this is dependent on the regional median income. It's basically tied to median income for the region. But in its general sense, a moderate income household is a household earning anywhere between 50% and 80% of the area-wide median income. A low-income household is classified as earning less than 50% of the area-wide median income, and a very low-income household is classified as earning less than 30% of the area-wide median. This gives you an indication, these numbers, of for different household sizes, what qualifies basically as moderate, low, and very low. And we also list in this exhibit the median income. And again, this is all dependent upon the region in which the municipality is located. Now, and we're going to talk about the Fair Housing Act in a bit, but and the Council on Affordable Housing, but ultimately, when that came into existence in the 1980s, the council divided the state into a number of different regions. Morris County is in a region together with Essex, Union, and Warren County. So this median income and the moderate, low, and very low incomes deal with those figures for this particular four-county region. And you'll see basically the incomes for low, very low, and moderate income for between 1 and 4 person households, just to give you an indication. Another thing important is how much do residents in affordable housing pay. And this table essentially shows you the typical rents and sales prices for, again, I guess this ranges all the way from very low, Liz, all the way from very low to moderate, with the left hand or the middle column being rents and the far right hand column being sales prices. And again, it's dependent on the size of the unit between 1 and 3 bedrooms. And by the way this is calculated is that the state has regulations that are referred to as UHAC, which is short for Uniform Housing Affordability Controls, and they limit the percent of funds that a household can contribute, can pay towards housing, both for sales and for rental. So just to give you an indication, for sales units, a household is not permitted to purchase a unit that would require more than 1/3 of the household income to be devoted, again, this is ownership, to payment of principal on a home, interest on a home, taxes, homeowners and private mortgage insurance, and if it's a condominium, a condominium and home ownership fee. And for rental units, the household is not permitted to lease a rental unit that would require more than 35% of the household income to pay both rent and utilities. So that's how basically these numbers in terms of affordability are derived. So this is what I referred to as part 2 of why Morris has to provide for affordable housing. And really what happened post that 1975 Mount Laurel 1 decision is that most municipalities pretty much ignored the Mount Laurel doctrine. There was no hammer that went with it, and not a lot was done affirmatively by municipalities to address their fair share requirement. And it led to a second Supreme Court decision, which was referred to as Mount Laurel 2, which is from 1983. And that decision went so far as to create specific requirements that, again, that every municipality in the state provide its fair share of the regional need for low and moderate income housing. And the towns were basically required, based on that decision, to provide this realistic opportunity. So what had happened is that many towns between 75 and 83 went out and they would zone properties that weren't developable for affordable housing. So they go find wetlands and they zone wetlands, or they find developed industrial sites or an isolated industrial park, and they zone it and say, well, we've done our responsibility to provide for this realistic opportunity. And the court basically said, no, no, no. You have to do realistic zoning and affirmative measures that will actually lead to the construction of affordable housing. So Mount Laurel 1 and Mount Laurel 2 are sort of the two decisions that would comprise what we now refer to as the Mount Laurel Doctrine. And Mount Laurel 2 also basically enhanced the mechanisms, if you will, that developers and public interest groups use to ensure compliance on the part of municipalities, the most common of which is referred to as the builder's remedy lawsuit. So the issue is, what is a builder's remedy lawsuit? So a builder's remedy lawsuit basically is litigation against a municipality on behalf of either a property owner or a developer, whereby basically litigation is brought to challenge the zoning for the municipality, basically challenging it on the grounds that it doesn't comply with the Mount Laurel obligation. and/or that municipality was engaging in exclusionary zoning. And what that landowner and developer does is basically say, I'm offering a site. I'm offering a site that can produce units, and the challenger will basically say, you haven't affirmatively provided for the realistic opportunity to satisfy that fair share. And basically, what would happen is that a court, basically, if it decided that the township was not meeting that affirmatively meeting that obligation, would basically conclude that basically the zoning in place was either, again, exclusionary or didn't provide the opportunity, and the developer basically can construct housing which provided a share of affordable units on that particular site that they brought to the table. And the court imposed what we refer to as a solution or a remedy. So the court basically would take the position that a municipality did meet its obligation. We're going to grant a remedy to this builder developer who brought this litigation against the township, and we're going to award him so many units at so many density on that land that the developer basically brought to the table. Essentially, through a builder's remedy lawsuit, the municipality loses all control over its local zoning and development and what it can or cannot basically say that a developer can do on a particular piece of property. The short lesson learned is that municipalities should do everything possible to put themselves in a position that they are not vulnerable to a builder's remedy lawsuit. So what is COA? You have probably heard the term COA, which stands for Council on Affordable Housing. What happened is that in 1985, after the Mount Laurel II decision, is that the legislature, the state legislature, codified the Mount Laurel doctrine in what's referred to as the Fair Housing Act. And the Fair Housing Act created this Council on Affordable Housing, or COA, as the administrative agency or authority over Mount Laurel cases in New Jersey. Basically took Mount Laurel out of the courts in 1985 and put it in the hands of the legislature, which basically adopted the Fair Housing Act and created COA as the administrative agent to basically be the overseer of municipalities and how they're meeting their affordable housing obligation. So, per the Fair Housing Act, COA was required to enact regulations that establish and then also update statewide affordable housing need. They basically were required to assign to each municipality an affordable housing obligation, again for its designated region. And then they were required to identify the delivery techniques available to municipalities in addressing that assigned obligation. I think there was also a 1986 lawsuit basically challenging the validity of the Fair Housing Act, and basically that was not successful. And I think that's sort of referred to as actually Mount Laurel III. What are the COA rounds? So COA, again, comes out of the Fair Housing Act of 1985, and COA adopted rules governing affordable housing in New Jersey for two periods, a first round and a second round obligation. The first round was from 1987 to 1993, and the second round was from 1994 to 1999. Basically, they are now known, they've been combined, and that 12-year period is now referred to as the prior round. And essentially what had happened in the prior round, or the first two rounds, is that COA assigned a fair share obligation to each municipality based on a methodology that I'll talk about in a little bit. And basically, municipalities then had the ability to file with COA a housing element and fair share plan and a petition to seek protection from COA from any future builder's remedy lawsuits. Or a municipality could choose to do nothing. And as you can well guess, that if a municipality chose to do nothing and didn't seek protection from COA, it was vulnerable to a builder's remedy lawsuit. Morris Township, and this is long before my time in Morris Township, but Morris Township had a prior round obligation assigned by COA of 293 units. And they basically did file a plan with COA to meet that obligation. And I'll get to that again in the next slide. So back during that first two rounds, Morris Township basically put together a plan to meet those 293 units. They did it through a number of different mechanisms. This is basically a table that comes out of our recent housing plan. It's probably hard to read, but essentially, it's in the handout, good. So essentially, the way that was met was through several means. There was roughly 20 units spread amongst smaller 100% affordable housing projects. There were, I think, 41 units that were in a combination of group homes and special needs housing, which qualifies for COA credits. There was 100 affordable units at the Morris Muse project. And then there were, I think, 200 inclusionary housing units that were spread over a variety of developments throughout the township. And by inclusionary developments, these are developments that include a mix of market rate and affordable housing. And usually they are produced at a ratio of 4 to 1. So in other words, that for every 4 market rate units, there's an affordable unit. And that's why the term inclusionary, meaning including some percentage of affordable units. So that's how Morris basically met its prior round obligation from 1987 to 1999. It was certified by COA. The township receives what's called substantive certification from COA, which protected it from future builders' remedy suits. And I'll get to what happened after 1999, because there was a period where nothing happened. But basically, it put the township in a position that it was protected moving forward into the future. So what actually happened, and this kind of came out when we recently did our third round plan, but Morris was eligible for bonus credits from that prior round, and that actual number of 293 units, we were able to get a total of 409 credits. There's a crediting system under the COA rules, and Liz actually worked it very well for our third round plan to get as many credits as we could, and we actually did some mixing and matching between the prior round and the third round to get as many credits as possible. So the bottom line is, when we went into the next round, where I'll get to, we had 116 units of surplus credit that we could apply to ultimately the third round obligation. Was there a third round? This gets a bit complicated, because again, this is now post-1999. So 3 times after 1999, COA tried to issue rules covering the post-1999 time frame, and also to assign obligations to municipalities post-1999. And each of these, in each of these iterations, they were struck down by the courts. And I won't go into the gory details, but there was something called gross share, which was struck down, and it bounced between the appellate division and the Supreme Court. But suffice it to say, I think in 2004, 2008, 2011, their rules and their numbers were struck down, and basically nothing happened. And I think in 2014, and Yolanta or someone can, what happened in 2014 is COA got deadlocked.
Yes.
They actually had new rules. They deadlocked at 3-3. In, I think, November or October, late 2014, they deadlocked at 3-3, and still nothing happened. And that's when, in March of 2015, the Supreme Court in the state basically said, enough is enough. And I actually think the Supreme Court didn't want any part of this, but they felt compelled because nothing had happened from 1999 all the way to 2015. So basically what happened was, in March of 2015, the state Supreme Court transferred affordable housing essentially back to the courts. Took it out of what was the legislature and the administrative body and sent it back to the courts. and now we have Mount Laurel 4. So basically the court process after 2015. So what the court did is it created 13 vicinages in the state, basically 13 courthouses to review affordable housing plans. And it basically said those courts could hear petitions from municipalities for certification of their housing plans, what COA was charged to do, which was to approve and certify plans. And what municipalities basically could do is that they could file what's referred to as a declaratory judgment action, or what we affectionately call a DJ action, with the trial court seeking to declare their housing element and fair share plan as being constitutionally compliant, and to further seek protection from the court from future builders' remedy lawsuits. And what basically has happened since that time, and is still happening as we speak in some municipalities, and I'll get to what Morris Township did, but it creates essentially a negotiation process. And that negotiation process involves, obviously, the municipality, in this case, Morris Township. It involves the Fair Share Housing Center. The Fair Share Housing Center is a housing advocacy group in New Jersey that was a party to the Supreme Court suit from March of 2015. And it also involves something called interveners. And interveners are developers and landowners who basically had sites that they were offering to provide for affordable housing, typically through inclusionary development, in other words, that 4-to-1 development. And they were allowed by the courts, provided they met a certain time deadline, to intervene in the DJ process. So you had all these parties before a judge. And to make things even more complicated, the judge basically appointed its own expert, known as a special master. And that special master's role was basically to attempt to mediate the process between the township, the interveners, and Fair Share Housing with regard to compliance with third round obligation. The Fair Share Housing Center basically was in a very, very strong position in these negotiations, and still is in any municipality where basically the township or borough is looking to further an affordable housing plan. They were effectively emboldened by the Supreme Court in the March 2015 decision, and they basically sit at the table during all the settlement negotiations, and they appear in court and basically have a strong seat at the table, if not the driver's seat, at the table in basically in this DJ action. And quite frankly, it's been our experience with a number of different municipalities in the state that basically, if Fair Share doesn't sign off on a settlement agreement, there is no settlement agreement. They have that much power in this particular process. Fair Share could also, if a settlement wasn't reached, ask the court to move forward with a trial, and basically also ask the court to go so far as to take away a municipality's immunity from a builder's remedies lawsuit. And that immunity was put in place basically once that DJ action was filed. It allowed protection, if not temporary protection, until basically the court process was finalized. So in the cases where a settlement was reached, and in Morris Township we reached a settlement, what happens next is there's something called a fairness hearing before the court, and the same parties appear, and the court basically at the fairness hearings makes a preliminary judgment as to whether the municipality's plan actually does provide this realistic opportunity to basically promote the what's referred to as the protected class. Protected class here is low and moderate income households. And then after the fairness hearing, the court usually gives the town 120 days to basically adopt the housing element and fair share plan, and implementing zoning if that's part of the plan. After that, there's a final compliance hearing where all these documents would have been in place and adopted and reviewed again by all these parties I mentioned. And if everybody is on board and the court agrees, the court would then ultimately give what's called a judgment of compliance or repose, which would give a municipality, again, protection from builder's remedy suits through the year 2025. So let me explain what happened in Morris Township. So this township, after that March 2015 Supreme Court decision, filed a DJ action to protect itself, and it did so in June of 2015. After June 2015, the township entered into negotiations with Fair Share Housing Center. There was an intervener in the process. There was, as I mentioned, a special master named Michael Boland was assigned to Morris Township. And there were a number of very tense negotiations, I think it's fair to say, the people who participated in them, with the various parties, most of which being Fair Share Housing Center. And ultimately, Morris reached a settlement in December of 2017. There was a fairness hearing. I think that was in February of 2018, if I'm not mistaken. And basically, the court gave Morris 120 days to do certain things, which was set forth by the court-appointed master, who was also all over us. Morris ultimately, including the implementing zoning, and I'll get to that, Morris ultimately complied, prepared an updated housing element in Fair Share Plan in May of 2018. There was a compliance hearing, I think, scheduled for June, but that got postponed until October. There was an issue that had arisen with one of the sites, but in October there was a final compliance hearing, and I think at the last day of October we actually got a judgment of compliance from the court. So essentially, Morris Township, as we stand and sit here this evening, has protection against any future builder's remedy lawsuit. It has a complying plan until July of 2025, when we're going to have round 4, believe it or not. And that's probably going to come up a lot faster than any of us think. I just want to indicate that what would have happened if Morris did not participate in the settlement agreement and negotiations, or did not file a DJ action. I think this is important, in that the court could well have, and probably would have, taken away the township's immunity from the builder's remedy lawsuits. And essentially, again, we participated in the process. We negotiated with Fair Share Housing Center. And if we did not do that, and if we did not reach a settlement with Fair Share Housing Center, we would have gone to a trial. And in fact, the judge had basically at one point set a date for a trial because we had not settled yet. And no one was ready for that trial, correct, John?
Thanksgiving week, yes.
It was like the week after Thanksgiving. And then I think she carried it to like Christmas week or something at some point. She meant serious business. But thankfully we settled the matter. But I just want to explain to you about what happened to the several towns in New Jersey that went to trial, because it was not a good result. There were 2 trials that took place. One was in Middlesex County, and one was in Mercer County. The first was in Middlesex County. One municipality in Middlesex County did not settle with Fair Share Housing Center. It was South Brunswick Township. They went before Judge Wolfson in Middlesex County, and we're going to get into a little bit about the third round obligation and numbers. But essentially, Judge Wolfson assigned them a fair share number for the third round of 2,900 units. 2,900 units was assigned to South Brunswick. In Mercer County, about a year and a half, 2 years post the South Brunswick decision, 2 towns remained in the litigation. Everybody else settled.
Princeton and West Windsor?
Princeton and West Windsor. West Windsor got hit with 1,500 units, and I'm rounding, and Princeton got hit with 750 units. So this is what happened to the 3 towns that decided that they thought they could do better going to trial as opposed to settling with Fair Share Housing Center. It was not a good result. I mentioned that we talk about the third round obligation, and this hasn't all been complicated already. There's even more complications here. But essentially, when the Supreme Court took the process away from COA in 2015, it neglected to do one critical thing. It neglected to assign a third-round housing number. I think the court didn't want any part of that. Didn't assign a number. Remember, COA was assigning the numbers. No number. You have to meet an obligation, but we're not going to tell you what the number is. So basically, what happened is that the court simply said that municipalities had to rely on the methodology, which was part of COA's prior round methodology, and it's very complicated. I won't get into the weeds. I don't even fully, I'm not a numbers methodology person. I prepare the plans, I negotiate these things, but there are about 3 or 4 people in the state that truly understand the numbers. And there's like 29 factors that go into the number. It's everything from census data, population, household projections, household generation, income, rateable base, availability of vacant land. It's complicated. And even though they said use the second round methodology of COA, different experts had a different opinion of how to basically utilize that methodology. And what ultimately happened is that there were 2 sides of the table on the estimates of the obligation. The Fair Share Housing Center hired their own expert named David Kinsey, and as you can well imagine, the Fair Share numbers expert came up with very high numbers in terms of what the obligations were. And then the municipalities, as part of a consortium, which we joined, right, hired their own expert, a group out of Pennsylvania called eConsult. And if we go back to that South Brunswick trial, remember I talked about? The judge in that case totally took the Kinsey number, the higher number. Took that number, didn't split it down the middle between the two, he took that number. In Mercer County, the judge basically did something more complicated, did a little bit of mixing and matching with her own methodology to vote.
But she was using a numbers math.
She had a numbers math, her own numbers math, but she didn't follow him in every way, and she decided that she was going to pick a little here, there, and do some of her own stuff. And essentially, a second set of numbers came out of that Mercer County, third set actually came out of that Mercer County case. By the way, these trials were lengthy and costly. I mean, I won't even tell you what it cost. Remember, there was 1 municipality left in South Brunswick, and Mercer in particular, which was a 5 or 6 week trial every day. And I know just from talking to people involved how much it cost the municipality. Really, really expensive. And then they got saddled with 1,500 and 750 unit obligations to boot. The other thing to keep in mind, that even though we have the Mercer County case, and essentially we now have numbers out of the Mercer County case, which have been applied to every municipality in the state based on the judge's municipality, we still do not have an accepted consensus third round municipal obligation from every county or vicinage to every county. That's how crazy this is. So let me talk something else about the third round, not to complicate anything more, but since we're complicating everything, we might as well give you it all. This issue of what is the duration of the third round obligation. So essentially, it was agreed that the third round or prospective need, future need, would cover the period from the Supreme Court decision in 2015 until 2025. The issue that was in question was, what should municipalities be required to do to address the obligation during this period from 1999 to 2015 when nothing happened? Remember, I went through the whole history of COA, the rules were invalidated, they were deadlocked. There was a period from 1999 to 2015 where nothing happened. This was litigated in the courts as well. And basically this period was referred to as the gap period, 1999 to 2015. And basically the court determined that municipalities had an obligation during this gap period. So not only did it have the municipality have the obligation from 2015 to 2025, but they had to make up for what would potentially have happened had there been COA numbers from 1999 to 2015. So the third round number got even larger. Combination of the 2 periods. And again, this I think could be referred to as Mount Laurel 5 when this decision was made. So basically, a municipality has to address both the third round gap obligation and the prospective obligation post 2015. Now we get to Morris Township and its obligation. So Fair Share Housing Center, member was using David Kinsey as their numbers expert, and as part of our negotiations, Mr. Kinsey believed that our obligation through 2025 was nearly 1,100 units. We negotiated with Fair Share. We basically got them to come down by 30% off that number. And then the resulting number was 767 units. However, we also were cognizant that Morris Township did not have sufficient land resources to produce that many units, and particularly through inclusionary housing, again, where it's 4-to-1 market rate to affordable housing. So we had the ability under the second round rules, which were never invalidated, to undertake what's referred to as a vacant land adjustment. And we did that. And what we did is we looked at every piece of property in the township, and basically we had to go through this process. We had to negotiate with Fair Share Housing. They went through our vacant land analysis. They challenged our vacant land analysis. They challenged our density assumptions on the vacant land analysis, and it was a fight. It was, yeah, and they actually filed a suit against us in the middle of the negotiations, believe it or not. Because they thought one of the housing sites that we had basically selected, right, and the developer was ready, willing, and able to develop it as an inclusionary development at a certain density with a certain set aside, and basically Fair Share said, you know what, we think the density's too low. We had a builder at the table that was going to produce the units. Well, we don't like the density. You have a high number. We don't like the density, so, you know, we're going to challenge the city. So we had to deal with that. And ultimately, I think that worked out very nicely because we had a cooperating developer who did not want it to be tied up in litigation, and he went over and above to produce additional units. But in essence, we did the vacant land analysis. And we came up with a number of 400 units, not 767. We got that 767 down to a total of 400 units. And it's referred to under the terminology as RDP, or Realistic Development Potential. So the question was, how then did we have to plan for 400 units of housing in this 1999 to 2025 period? So essentially, going in, one last thing, if this isn't bad enough. The difference between the 767 units and the 400 units, which if you do the math is 367 units, never goes away. Even though you don't have the resources to do it as part of your plan, it's referred to as unmet need. And Fair Share Housing, and I'll get to that, also expects you to meet some portion of unmet need through something called overlay zoning, which I'll get to, but it never goes away. So how do we address the 400 units? This is in the handout, and I think comes right out of our plan. So we had a couple of favorable things going for us to meet the 400 units, which I think really helped in putting together a plan. Number one, we had, as if you recall, 116 units of surplus from the prior round. Okay, so that's over 25% of that 400. That was huge. We applied that. Fair Share Housing agreed. We credited that. Liz was terrific in the way she manipulated that. She manipulated it so well that I didn't even understand it, and Fair Share didn't even challenge it. So nice job. We got 116 units. We then also had the benefit to get rental bonus credits. Okay, and you can get up to 25% rental bonus credits of your total obligation. So our obligation was 400 units based on the RDP. We were able to get credit for 100 units of rental. We never had to build them. We just got the 100 credits. So now we have over half our obligation. We didn't have to do anything, which was really favorable to us. So we have 216 units. We didn't have to build the thing. We didn't have to zone it. So ultimately, to get the remaining units, which I think was 186, we had several things in our favor. We had the Honeywell site, which was already approved and was assigned as set-aside, which was going to produce 24 affordable housing units. That was already in place. It was zoned. It was probably approved, if not in construction, at the time we were putting the housing plan in place. We then had the Colgate redevelopment site. We're doing a redevelopment plan for Colgate, which, as you may or may not be aware, consists of a mix of retail, commercial along the Hanover frontage and housing in the rear. We had a developer who was basically willing to build townhouses as the market rate product, which we were looking for at a low density. And affordable units, including a number of supportive housing units, were part of that plan. And that plan produced 66 affordable units. And thanks to that developer who stepped up to the table to provide an additional 30 units to settle that lawsuit with Fair Share Housing when they challenged the density and said it was too low. We then have a number of other sites which you may or may not be aware of. The Sisters of Charity site on Punch Bowl Road is producing 33 affordable units. There is the former Morristown Hospital Atlantic Health System building, which is producing 23 units. There's a small project also on Mount Campbell producing 7 units. And there was one use variance for a project also on Mount Campbell where the developer was required to do an off-site unit. And and there were also scatter site affordable housing projects, some of which were approved, some constructed that we took credit for. And we actually had to provide some funding through our Affordable Housing Trust Fund, where we have monies for projects that were being undertaken by Morris County Housing Authority and Homeless Solutions. And those and other projects produced another 30 units. So we made up those 184 units. So again, to meet that 400 units, over half the units we never had to build, which was really favorable and beneficial to the township. We also were required, I mentioned on the unmet need, the 367 units. So Fair Share Housing basically said you have to do 2 more things. You have to adopt a mandatory set-aside ordinance. What a mandatory set-aside ordinance essentially says is that if you, Morris Township, decide in the future through either a affirmative rezoning, a redevelopment plan, or a use variance to be granted by the Zoning Board of Adjustment for any project that involves 5 or more residential units, you are required to provide a set-aside of 15% if it's rental, 20% if it's sales. Okay? Now the good thing about this is the municipality is under no obligation to affirmatively grant the use variance, do the rezoning, do the redevelopment. It's at its discretion, and it says that right in the ordinance. We made sure that language was in there when we settled with Fair Share Housing. All it says is, because you have that unmet need, that if you decide as a matter of public policy to do future projects that involve housing for 5 or more units, you have to set aside some of those units for affordable. That's all it does. If a developer basically comes knocking and says, you know, I want to do this or else I'll do a builder's remedy, no. We have compliance, we have a judgment of repose, and it's very clear in the ordinance itself that we're not required to do this. It's at our discretion. That's really, really important. The last thing I mentioned was the overlay zoning. Remember, we have 367 unit unmet need, and they basically asked us to look at a number of mostly industrial sites. And the bulk of these are actually on Hanover Avenue in the industrial zone, and put in some overlay zoning. Now, the overlay zoning doesn't eliminate the underlying zoning. So, for example, we have about 5 sites on East Hanover, and we put in an overlay zoning allowing multifamily as an additional permitted use, I think at 10 units per acre. But that doesn't take away an owner's ability to continue to use that property non-residentially or to expand it, demolish it, build new under that zoning. All it does is provide another development option. And Liz, you may know the exact numbers, but that overlay zoning only built 60 to, one of the zones has a varying density, 60 to 80 units. So you're not even making up 20% of the unmet need, but we thought fair share was, like we said, that's enough. We're not doing any more overlay zoning. We finally settled that matter. And essentially, that's how we arrived at our plan at this point. So, and I'm almost done. So what happens next is that for Morris Township, so all the implementation measures, including the zoning, they're now in place. So we're protected through 2025. The fourth round will begin in July of 2025. But thankfully, that seems such a long time away, even though it isn't, because we finally settled this matter. What will happen post-2025, if people are wondering, right now this is in the courts as opposed to the legislature and the administrative body, but the courts have determined, the Supreme Court in New Jersey determined that the constitutional obligation to provide for affordable housing is a continuing obligation. So we can expect a round four. Whether it's in the courts, whether the legislature steps up and does something, we can assume that there'll be a round four that starts in 2025, and we can assume that post-2025 there will be a compliance either with the court or with COA, and that will be assigned a number, or we'll have a number, and we'll have to go through this all over again. But right now, through a very difficult and challenging process, we are in a good position, at least for the next 7 years going forward. So I'm sorry I was long-winded, and I know this is complicated. History is beneficial, and now we'll open it to questions. And yeah, Tim.
Can I make one comment? As you said, when the Kinsey report came out, that was 1,100 units. That's affordable units. If we went to court and we lost, and the court said we need 1,100 units, that's 5,000 housing units that had been built.
We can't hear you back here.
Yeah, we can't hear.
Maybe the mic's on. If you look at the 1,100 units that we had the potential for, that's 1,100 affordable housing units. But to accomplish that, we would have had to authorize 5,000 housing units to get to that number. And that's
Based
why-
on that 4-to-1 market rate to affordable. And just that math, South Brunswick, 2,900 units, multiply that by 5.
Right.
14,500 new units for a municipality to try and absorb.
In many municipalities, it would require the municipalities to have more than double the existing residential development. And I apologize for being late. I'm Steve Warner,
Steve Warner.
Planning Board Attorney.
And by the way, Fair Share Housing does not care about the impacts upon services, schools, or what have you. It's, here's your obligation, we don't care, you need to meet it.
It doesn't matter. I represent municipalities as Affordable Housing Council, and I can tell you that there are developers who are pushing to get numbers that will double the population of some of those towns that I represent. So it's real. It is happening, and we were hoping that it wouldn't get to a builder's remedy, but it did. And it's unfortunate that this is a better position to be in, certainly.
And by the way, just let me give you one other thing is, I mean, I think the township also understands, we're all talking about, keeping the number down. So the township recognizes that it has an obligation. We all recognize that providing affordable housing is a good thing, and we all understand there's a constitutional mandate, and we all think that it's really desirous of municipalities to meet that obligation. It was just the enormity of some of the numbers that were bandied about that we had to deal with here, that we just felt our municipalities simply could not absorb those numbers and or plan for those numbers in a manner that was consistent with sound planning practice, without affecting neighboring properties or the community as a whole. But I really wanted to make that statement because we do acknowledge that there's an obligation to do this, and we certainly met that charge. And long before I was here during the first round, the municipality met that charge, and we can't say that for all municipalities in the state. Many rolled the dice during the first 2 rounds, and I can tell you they're paying for it now, and some of them are paying for it in terms of builders' remedies, including municipalities that I represent. And I can tell you with some of the densities that are being thrown about in these builders' remedy negotiations.
We
I'm
built-
sorry, Tim.
No, we built our first units in 1987 and continued on and continue to do so with current projects.
You have to speak into the mic, we can't hear you.
Sorry, the mics are off. We started, our first units were actually built in 1987, and we built all through the 90s and continued on meeting those obligations. So it certainly helped us as we went into our litigation to get our protections. Because there are some contiguous municipalities that did not, and they have a significant number that they have to now meet.
Can you hear?
Can they stand up when they talk?
Yeah.
It might be
Yeah,
better.
turn on the mic.
Turn the microphones on.
Yeah, can we turn the mics on?
How about go for Mike?
The microphones do not amplify.
See if we can get some.
Not everyone's as loud as me, Liz.
I won't need one, I can assure you.
I don't even want to.
And I am standing up, in case you were wondering.
I want the text one.
I have a question that connects with what you were just talking about as far as the numbers. So those numbers where affordable housing is a 1-to-4 ratio, affordable to market, that's one delivery method, correct?
Correct.
But there are other delivery methods that
Correct.
some towns have chosen.
That is correct.
Can you comment on what those are?
Sure, the most common form to do it is through the inclusionary zoning, the 4-to-1, where the developer basically steps up and is responsible for providing the affordable unit. The theory being that the developer usually gets some kind of density bonus, which would allow him to then internally subsidize, if you will, the cost or underwrite the cost of providing that affordable housing. But, for example, certain municipalities have done 100% affordable projects, including Morris Township in the prior round. You did a very large 100% affordable, meaning either the municipality, if it chooses to be the developer, and a lot of towns don't want to get into the development business for good reason. It's complicated. Or they will work with a nonprofit or a Morris County Housing Authority, and the real issue with the 100% affordable is the funding source. And so, for example, what happens is if there are funds like affordable housing trust funds, you could add that to the pot as a sweetener. You can basically, sometimes municipalities donate land as part of the equation, because land is part of the total development cost. And you find a way through these sources in order to do this. One of the things that many developers in New Jersey seek to do, and there are probably half a dozen companies that do 100%, is there's tax credit financing in the state. There's several forms. The problem is it's highly, highly competitive. Everybody's out there competing for it. And ultimately, what COA, what the Fair Share Housing will do is that if you include it in the plan, they will often balk or push back or make you prove that you have a guaranteed funding source, and they will go so far as to require the municipality to actually bond for the monies to make it for any shortfall that can't be provided through tax credit or some other means. So it's been done. It's been done in Morris Township.
We explored it
Yeah,
as part of
and
this.
we actually have 30 units as part of the third round that are 100% affordable. They're small scatter site projects that have been done mostly by Morris County Housing and Homeless Solutions. That's 30, they're not big projects, they're small, but they're 100% affordable. So we don't have all 80-20 or 4-to-1 housing. In fact, the Colgate developer stepped up to the plate and basically gave us 30 more units of housing, and is also doing 6 units of supportive housing.
About a 35% set aside.
Yeah, equated to a 35% set aside, where the typical set aside is between 15 and 20%.
If I recall correctly, that might have been a 6 unit to the acre density as opposed to.
And when he did the additional 30, went to 7. He went from
That's
6
correct.
to 7 units per acre, so we still kept the density low on that particular site. But essentially, you're correct, Kathy, there are other ways to do it, but they are
They're
somewhat
expensive.
more, they're expensive and complicated, and Fair Share will hold you to the fire on the issue of the funding. Because every town is like, well, I don't want to absorb all these units through inclusionary. You know, it's so many more units, so let me do the 100%. It's 1-to-1, it's not 4-to-1. But Fair Share, knows this, and what a lot of towns did back when they were filing with COA during the last filing in 2008, is they put together a phantom plan.
Yes.
And they'd say they were going to do these things and just kind of kick the can down the road. and wait for either COA or, as it turned out in the courts, Fair Share Housing, to basically step up and say, no, 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 this isn't going to work. If you want to include this in the plan, here's what you have to do. And it's money, money, money.
Has Fair Share been involved since the beginning, like the early 80s?
No,
No, it hasn't.
no.
The Fair Share Housing Center was designated in 2015 by the Supreme Court as an entity. They're a nonprofit entity, and they allegedly stand in the shoes, and they actually do. They stand in the shoes of low and moderate income households. So they are an organization that protect the interests of people who would benefit from this type of housing. So they were designated as a quote-unquote interested party, but they are a party to the litigation, and they have been the party that has been settling all of these cases on behalf of people who require the affordable housing.
The predecessor was known as the public advocate.
That's right. That's right.
I've heard it said that Fair Share Housing is heavily funded by developers. Is that accurate?
That's what everyone suspects, and I believe
There have been
that's,
subpoenas to discover that.
there have been, and at least some of the funding sources that they disclose on their website, you can take a look at their website, fairsharehousingcenter.org. You know, they do disclose some of the funding sources that they get. They don't disclose necessarily builders in particular, but I can't imagine that they are not being at least assisted by the Builders Association.
And suffice to say, there's an obvious mutually beneficial interest
Absolutely.
between Fair Share Housing and the New Jersey Builders Association and various developers, because when a good chunk of the mechanism for meeting the affordable housing obligation is inclusionary development, 4 or 5 or more market rate units for each affordable housing unit, then invariably Fair Share's success in increasing the number of affordable housing units has an exponential benefit to the various developers who are interveners.
Who are licking their chops.
Yeah.
Who are licking their chops, yes. So,
Sounds like an unholy alliance.
That's what we used to say, it's making a deal
we
with
would
the
never
devil,
say that.
you know?
But it is what it is.
Who's in charge? Are you in charge of the call? Or you want me to
Go
do it?
ahead, you're,
Go ahead.
You're standing, Paul.
The location is essentially dictated by the builders,
Well,
or where these
Can you repeat
housing
it?
is
The
located.
question is the location
Can't hear
dictated
now.
by the builder?
let me do it. The question was, are the locations for the housing dictated by the builders? And the short answer is, if a community seeks protection, and as we did through our DJ action, from builders' remedy suits, and as we did when there was a COA back during the prior rounds, the short answer is no. The municipality gets to plan for where this housing should be located. However, if a community does not seek those protections, then it has exposure to a builder's remedy suit, and then it doesn't get to decide basically the location. Because unless that site under a builder's remedy suit that a developer offers is not suitable, unless it's 100% wetlands or 100% steep slopes, it's basically going to be awarded a builder's remedy suit, and it's not a question of whether, it's a question of how many units. So the answer is it depends.
Subsequent question.
Okay, he's got a follow-up.
We allow
By
follow-up.
2025, the population decreases. Are we still expecting an increase in the quota?
I think that, as I mentioned, given the fact that the courts have ruled that this is a continuing obligation, that unless there's some drastic change, which I don't foresee, that there will be a 4th round, and this municipality, as well as every other municipality, is going to be required to basically provide some realistic opportunity to meet whatever that number, which remains to be seen, assigned to this municipality is.
Which is-
I mean, would you agree?
Yeah,
Yeah.
for the benefit of the members, for the people further back who may not have heard the gentleman's question, the question was, if we're to assume that there's going to be a population decrease in 2025, presumably statewide, possibly in this municipality. Is there still going to be a continuing obligation? And you heard Paul's answer, there's still going to be a continuing obligation. I don't know, Paul, I apologize for this, did we talk at all about growth share? And
Yes.
We talked in,
Somewhat.
I didn't want to get so heavily into the weeds, but we said it was invalid.
Keep it at 10,000 feet. But the idea is that the indigenous need is beyond just this municipality. We are part of a region,
Yeah.
as Mr. Phillips explained. So even though Morris Township's population, however unlikely, might decrease, it would depend on what was going on within that larger region, of which we have a duty to offer a supportive share of the housing.
Right. And there's a difference between a constitutional obligation, which the court imposed on us forever, because the court said that's what the Constitution says, you have an obligation. So there's a difference between that, and there's a difference between what the number will be. What we're hoping for by 2025 is perhaps we'll have another COA, or something akin, something like COA. You know, I
Which-
never
which
thought we'd say that we
Suggests that
missed
the
COA.
legislature is going to have to step up.
Well, they
Because
are.
there will be no new COA unless the legislature moves.
It really is in the hands of the legislature, and there have been many bills over the last, I'm going to say 10 or 15 years that have tried to deal with this. There were bills that tried to amend the Constitution to remove this. They went nowhere, but there have been, and they're still trying. There are still bills now that are trying to gain some traction to change the Fair Housing Act, to change the way these numbers are, you know, are defined and how many units municipalities owe.
And there is precedent, as you heard earlier, for the legislature to step in. In 1985, the legislature stepped in with the Fair Housing Act
And
to
how did
stem the
it-
tide of builders' remedy suits that were dictating what the obligations would be then. But we're not holding our breaths.
No, we're not,
It's a good thing we
that's-
haven't held our breaths over the last
Correct.
2.5 years.
But that's one thing that constituents can do. Contact your legislators. Contact the legislators in other districts who are the ones who are blocking these bills. You can find all of that out on the legislative websites in Trenton. Contact them, write letters, and tell them that you want these bills to pass, that you need this mess fixed. I have been telling people this for years, and it hasn't happened, but that's what we need to do. We need to get those legislators that are willing to fix the problem some support.
I'm going to go ahead.
The other towns that haven't settled and are continuing to litigate, like I know Randolph is one, for example, and I'm sure there are others. Given the parade of horribles that you've identified and the negative consequences that are likely to ensue in going all the way to trial and likely getting a very high number, what is the logic behind towns that have not settled? What is their argument for not coming to the
You
table?
want the honest answer?
Sure.
Shall I be honest?
Be honest.
Of course.
It's politically, in some cases, difficult to basically affirmatively address this. And some municipalities, in my opinion, haven't stepped up and basically confronted the problem and attempted to deal with it in the best way possible to protect the interest of its residences, and they just hope that by kicking the can down the road, that it may go away at some point. But the chickens probably will come home to roost, and I know other municipalities that are in the same position. And ultimately, if they go to a trial, I think they're really putting themselves in a vulnerable position.
Think about the
I mean,
obligation.
is that a fair statement? I
No,
mean,
it's fair, and
I
then
mean,
there's another thing. Some towns have very, very many interveners. They have many developers that are banging down their doors to get in there because they haven't developed for years, because they weren't as proactive as Morris Township was. So their numbers are much, much higher. They have many, many more developers, and they're trying to wait them out. I don't think they will.
Unlike Morris Township, they didn't have 116 surplus credits from the
Right.
prior rounds. They may not have been able to avail themselves of the vacant land adjustment the way we were able to avail ourselves of that to reduce the gross number of affordable units down to the realistic development potential number, which was much lower, 367 units lower. And I agree, litigation is the most expensive and often least effective way of resolving something. It's the last resort. And the municipalities that have worked together as a consortium and spread the cost, they're diminishing by virtue of the settlements that are happening increasingly over the last 6, 8, 9, 10 months. So you don't want to be, in my opinion, in the caboose, because it's going to be very expensive and the exposure is going to be very significant.
I mean, the other thing is that, you know, I participated in the negotiations in Morris Township, and I think that in terms of issues such as basic densities, and we negotiated the zoning and so forth, we're at relatively low densities compared to what other towns are facing. I mean, the Colgate site was 6 to the acre and then went up to 7 when they agreed to do 30 additional affordable units on their own dime. Some of the other sites are at, I think our biggest site is maybe like 11 units per acre in terms of density. The other sites are ultimately, the
7,
Sisters is
8,
6, right?
6.
Sisters is 6.
I think you have a 7.5, don't you?
We have a 7.5.
The larger density of.
And even the overlay zoning, Fair Share Housing was pushing for 20 to the acre. And we basically, for most of those, came back at 10 to the acre. Yeah. So, again, it was all part of a sort of a challenging negotiation.
Well, in the old days, you used to be able to put a certain portion in other towns
Oh, yes.
possibly.
Yeah.
Yeah, we
Regional
love-
contribution.
Right.
We love that.
And so where I'm heading on is this next in 25, if we're going down, could we put it in another part of our region?
Repeat the question.
The question is that under some prior iterations and rules, municipalities were able to basically shift up to 50% of their obligation through something called a regional contribution agreement to another municipality. It usually involves sending money along with it. So, and that other municipality had to be within your region. So, for example, and I'm just going to pick municipalities that had, whatever municipality in a county, let's say outside Hudson, but was part of the region, was sending monies to Jersey City to do rehabilitation. And they can meet 50% of their obligation that way, but ultimately that was invalidated.
It was invalidated, the court said no.
So,
So even going forward,
Yeah.
if we
you
have
know,
a
a lot
reduction-
of municipalities availed themselves of the RC, the regional contribution agreement, but now it's not,
Off the table.
it's off the table.
Completely.
Who are the 4 counties in the region again? In our region?
It's Essex,
I know.
Union, and Warren, and Morris.
How do they decide that those should constitute a region? I mean, you go from Hudson over to Warren, you have quite different circumstances.
No, it's not, Hudson's not in it, but your point is well taken. It's Essex, Union, Warren, and Morris, but some demographer planner who looked at, census data and trends and so forth, decided in COA that this should be a region of the total of, I guess, 6 regions that the state was divided into, and said, here, Morris, you're in this region with these 3 other counties.
Well, we got a question over here.
Yeah.
Yeah, I had I don't need a follow-up, but just a couple of little questions so I can understand. You talked about the 3 different levels of affordable housing within a 4-to-1 ratio. Is there also a formula for how many are the very low, low, and moderate? That's one part of my
Yeah.
question. When the builder builds, let's say on the Menon site, are all of the affordable housing units separated? So they're in their own little pod, so they're segregated from the fair
Right.
market ones? That was another little one. And you talked about the East Hanover overlay. That
Yeah.
goes from where to where on East Hanover? And what's the density? And are those inclusion sites or are they standalone sites?
Okay, so
That's
I
enough for now.
I'm gonna get this right.
Okay,
I'm gonna get this right.
okay.
Okay, so the first issue was the distribution of the affordable. So there's a requirement that 50% of the affordables have to be low and 50% have to be high. Moderate. And then of the 13% of the low,
be very low.
have to be very low. That's the 30% number. So that answers that.
Okay.
I'm going to deal with the integrating the units last. The East Hanover overlay, it's not contiguous, but there are, I think, 5 sites, and there's some of the older industrial buildings. I think there's a self-storage warehouse in there.
East of
This
Ridgeville.
U-Haul, I think, is in there.
But it, like, is it from the
East of-
Arboretum up to Ridgedale?
Yes, between the Arboretum and Ridgeville.
Yeah.
And then does it go beyond?
You know,
towards
then it goes down
Monroe?
down John Street towards the jail.
Okay,
And the density's 10 units per acre.
so it's there, it doesn't go from Ridgedale to Monroe?
No.
on the
No,
R1?
it does
It's
not.
everything
Okay.
east of Ridgedale Avenue.
Okay,
Okay, and your last question is the affordable units.
yeah.
So, there are 2 ways to produce the affordable units. To integrate them within the, with the market rate units. Traditionally, that's been the form of choice through time in terms of developers producing affordable housing. The integration of units was also encouraged by COA, although not required by COA. So while they encouraged it, it wasn't part of their rules, you didn't have to do that, and they were willing to look at each particular development on a case-by-case basis. So, for example, in Morris, we have certain projects which are integrated, and the affordable units are interspersed with the market rate units, and the theory being that if you're looking at the units from the exterior, there's no change in the material, so you can't really basically distinguish between a market rate and affordable. However, certain developers, depending upon the circumstances, have looked to separate the market rate and the affordable. And in some cases, what happens is that a developer who's building the market rate doesn't build the affordable, and he either flips it to someone who's capable of doing 100% affordable with experience at doing it. Sometimes it's a nonprofit, sometimes it's another developer. So it's really, it depends on the circumstances, and in fact, in Morris, we have both integrated and we have 100% affordable.
And on the Colgate property, it's for sale market rate units and rental units.
Yeah, that's-
for that to meet our requirement for the.
Yeah, Tim brings up a good point. We were playing a numbers game to maximize rental bonus credits.
Right.
And essentially, that helped us on what we did in Colgate, because if the Colgate affordable units were sales, like the townhouses, we wouldn't have gotten those bonuses. So they were rental, they were separate in the rental. And they're also, in terms of just legal condo document issues, it's very difficult, if not impossible, to mix and match the sales and the rental like that. But I will say that historically, when this first started in the 1980s, most of the developments were fully integrated, for the most part. But that's changed, and again, it's fact sensitive. Questions?
So who owns the affordable rental units, and how do we know that they are maintained that way? And then, of course, the corollary is for the townhome units, and I think I can even pick out which ones they are over at Honeywell.
Right.
They're so narrow. How are they transferred? How do you keep it so we don't lose the fact that we created these or
Good question.
appropriated? It's a very good
Which one of you four wanted to, because you all agreed that you would
Well,
take
the
these
four cells are
questions.
all deed restricted. So they are deed restricted for 30 years. And what municipalities do before the 30-year deed restriction ends on some of these units is they approach those property owners and they deed restrict again for another 30 years. That's what we've been doing in other towns.
We have an administrative agent that handles all of the sales for the affordable units. So they have to go through them, and then they get a very small commission on that. I think it's 1.5%. So there's no cost to the municipality. But if you have an affordable unit and you're ready to sell it, you've got to sell it through the administrative agent that we have. They're somewhat the realtor, broker, and they bring the sides together and put the deal together, because really when it comes down to money, that money's already set as to what the state has said that market rate unit, I mean that affordable rate unit is at a certain price, so there's really no negotiation on the cost of it. And then on the rentals, the obligation is, like Morris County Housing Authority has Morris Muse. They are responsible for that. They have to report back to make sure that anybody that is there is meeting those requirements for the income levels to that, and that they qualify.
Who's the landlord?
Yeah, but
Morris County Housing Authority.
So they own the individual
No,
units?
no, they
No, no.
don't. The developer would own the units, but it would be a system where they're operated under the control of the Morris County Housing Authority.
and is that for all of the rental affordable housing? Or all
Primarily, yes.
rental?
There's a landlord, basically. Municipalities in some cases do operate their own. We do not.
Do not.
And then does the owner of the rental community, they receive income from the housing authority, Morris Housing Authority?
I don't understand the question.
Well, if the rent is paid to the Morris
County Housing Authority,
Morris County Housing Authority, they keep all the money?
yes. They have to maintain.
No.
Well, on rentals, does the
Yeah,
county?
right, but they've got to maintain it through
Oh, yes, yes, the structure of the allowable rents and the qualification process is handled through the auspices of the Morris County Housing Authority. But the developer, the builder, is a landlord in a sense,
And the housing authority pays them?
oversees them, yes.
The property managers.
That's it, but the property manager.
But we do have properties that Morris County Housing Authority actually owns, as does Homeless Solutions. So they do both roles.
What, just another little quick one. Some of us feel that there's a lot of development in town. If we restrict our development, how does that impact our future? I guess it's, if somebody wants to sell their property, then of course you're faced with this. But if people don't sell their properties and people don't divide up their 5-acre home estates, and a developer says, well, I can develop this, are we going to still be responsible, even if, let's say, we don't develop anything over the next 8 years?
I'll kick that one back to Paul. I think the,
Right, and nobody sells any land.
They would have to go through the appropriate land use boards in order to subdivide that property to do so.
But if nobody sells any property,
The constitutional obligation is still there.
well, where would they get the land?
but I understand your question, it's dealing with the availability. If a property is unavailable, it's unavailable. I mean, you could have a 20-acre piece and you choose to keep your farmhouse on it, and while it might be zoned for 10 units to the acre, if you decide not to part with it, nothing happens.
But the obligation is still there. So it's, what is it, a whack-a-mole? I think was the old game on the boardwalk. You got, even if it doesn't pop up, it's gonna pop up over here. It's gotta go somewhere, constitutionally.
Right.
What if there's no land available?
Well,
What if no one
realistic-
sells land?
Well, realistically, in some towns, there is no developer ready to build, and there really isn't land available. And what they've done is they've done some overlays over things that might happen in the future. And, you know, in some of those towns, those things are happening, slowly but surely. There are people who do decide at some point to sell their property, and that will come to fruition. But if it doesn't, there's really nothing a municipality can do, because all you're required to do is provide that realistic opportunity. And once Fair Share Housing Center agrees that your plan provides that realistic opportunity, that's all you can do.
And remember, we sought and were given a vacant land adjustment.
Understood, I'm
Yeah.
just trying to look at it.
Is the town going to be required to give up green acres?
No,
Never.
No,
absolutely
Never.
not. Absolutely not.
It's near impossible to get your property back off
When
the
we
lawsuit.
did the
Near
vacant land,
impossible.
when we did the vacant land analysis, Green Acres lands, county, state, federal parklands, all excluded, all off the table.
Yes. Can we ever have new green acres? Or no?
Well, that, you can do that independent of the affordable housing.
Right, but would that conflict, and they'd say you're trying to pull a fast one, it takes some more.
Well, there's a certain percentage of land that you can dedicate to recreation based on the rules, but we didn't have to go there at this point, but there's the potential to provide that protection. God forbid in around 4.
Oh, we have a question back here.
Yeah.
Are you aware of any significant research which shows which affordable housing models maintain their value the best over time? In other words, well, if they're developing next to my townhome, what I'd like to think is that 5 or 10 years from now, their value is going to increase like mine is, or do they not? And which kinds of models have worked out better? That's what I'm asking.
Well, the prices are artificially restricted on the affordables, pursuant to some formula that's beyond my comprehension.
But the market should still pull them up, right?
No,
Not at all?
no,
Ever?
they're restricted.
They're restricted.
They're
The price is
restricted.
At all,
restricted.
or do they go up a certain amount?
The price goes up a very
Very
small
small
amount, a very small amount. If you go to resell, there is a percentage, but it's very, very small. You can't buy one of these units and expect that you're going to retire on your proceeds. It's not gonna happen.
No,
On the order of the cost of
Right.
living.
Oh, no, it's
Adjacent homeowners is
Oh,
what
no, no,
I'm
I
thinking about.
understand. Oh, yeah,
I'm an
absolutely.
adjacent homeowner, you know, I want to think about what's going to happen in 10 or 20 years. What is the model that's going to help the whole community so that prices don't decline where I am too at the same time?
That's a great question, and I don't know that any studies have been done. I don't know.
I don't either.
There are studies that have been done.
Really?
And studies that show the impact of home prices with affordable housing units in close proximity.
It's more of an appraiser type question, actually.
Exactly. Do you know where we can access those types of studies? That's an interesting.
I'll check, I'll get back to that.
Section 8, is that coming?
Well,
No.
Section 8's a federal program,
It
and
is.
that really,
It
we're
is.
not,
You don't get credit for it.
Yeah, we can't get credit for Section 8. I actually represent a town that has an entire development that is funded by Section 8, and we can't get credit from COA for that entire development, even though it is low-income housing and it is largely funded by the federal government. So Section 8 really is an individual thing. It follows the individual. Somebody living in Morristown can have Section 8 and then take that Section 8 and move to Morris Township. So you really can't restrict property based on Section 8.
Section 8 also most often funds market rentals
Right.
to assist folks of limited income.
Mhm.
So it's not really driven or directed or aimed at the affordable housing units. It strives to take a regular rental unit and make it affordable through assistance.
The properties on Punch Bowl, will they be rentals or will they be purchases?
I couldn't hear him.
Is Punch Bowl for sale or rental?
Rent, the affordable housing.
the affordables are
Right,
rent.
rentals.
I apologize, I got here a little bit late, so I just wanted to see, when you talk about the certain amount, we are responsible for a certain amount of affordable housing, is that per year or all total, and you've got to a certain year to get to that total?
2025.
And how many units is it?
Well, there's a prior round obligation, which we already met, which deals with the period from 1987 to 1999, where we had an obligation of 293 units, and we met that. And then the third round obligation from 99 to 2025, basically, based on negotiations and our lack of vacant land, was 400 total units. And we put together a plan that met those units, and we have protection from any future builder's remedy suits through 2025. So we're fully protected at least for the next 7 years.
And that plan included 116 surplus credits from the prior round that the municipality was prescient in having available by virtue of its proactive stance through the earlier rounds.
And 100 rental bonus credits. So as I don't know if you were here, but as I mentioned, of the 400 units, over half of it we got credit for without having to produce anything.
So have we met what we're supposed to so
Yes.
far in 225? So we don't technically have to,
That's correct.
since all the plans are in for these different ones like Colgate, and
Yes,
we've met ours,
We
we don't
have.
have to.
Right.
Okay, so what is being proposed at the Madison Hotel
No.
is completely separate, there's 30 supposedly units going there. Is that separate?
The set-aside ordinance.
Yeah, so there's a zoning board application before, involving the Madison Hotel,
Right.
which I think it's 119 units total, and they're proposing 15%
18
set
units,
aside.
right.
They're proposing the 15% set aside based on the mandatory set aside ordinance. However, and I don't know if you were here when I stated this, that mandatory set aside ordinance, the way we've structured it, the way we've worded it, okay, the zoning board, like the governing body with a potential rezoning or redevelopment plan, is under no obligation. We've met our 400 units.
That's what I'm.
So they can't use as a planning rationale for the use variance, they cannot say that this is being done to meet your RDP because we've already met it. They can argue any other thing they want for it, and the zoning board will hear the case, and they'll deliberate, and they'll decide accordingly, but we don't need that site to meet our obligation.
But they still have to build those units if it's approved.
But if it's approved by the zoning board, they do have to build that 15% rental set aside.
Right.
Only if it's approved.
So at the rate they're going, they're talking, if it's approved and all, there's plenty of ways, there's still time that they have, or a lot of processes to go through. So if it's approved and they don't build till 2020 is when they begin, and they're done at 2025, will those then credits be given for the following 2025, round 4, as you say? Would it be applied to that possibly?
Potentially, yes.
Okay.
Yeah, if everything else comes to fruition, then those credits would be available under that hypothetical
Yeah.
to go forward for the fourth round.
If your number's X and you've built Y,
Yeah.
it's X minus Y, so.
Anybody else? Anybody else? Go ahead, you got it. The floor is yours.
Even if all municipalities meet their affordable housing requirements, is there still an unmet middle and low income housing need in the state or in parts of the state?
When you say middle income, what do
Well,
you, that's the thing that's
whatever
throwing me.
qualifies as the level that becomes middle income under the affordable housing plan, if we use that as to define what middle income is there still an unmet need for affordable housing in the state, even if all these requirements are met by all the municipalities?
Theoretically, no. If everybody met the need, then there would be no additional need until the next period came into play and new numbers would be assigned.
Legally, by definition, economic analysis has been done as to whether
Yeah, well, that's another issue. The state hasn't even agreed on what the need is.
Correct.
I was gonna say, I think there's
So
a
that-
bridge,
yeah.
there's a bridge in Brooklyn somewhere that's in sale as well.
To follow on the Madison Hotel question, so if they do build those before 2025, why wouldn't those go towards our unmet need?
So that's an interesting question, and ultimately, and we can play this out, but let's say that we're putting together a plan in 2025, and although we had an unmet need of whatever number of units, it wasn't part of our overlay zoning.
367.
It wasn't part of what we put in to meet the unmet need, and even though we have the affordable housing set aside, we would, at least as I stand here today, Jeff, I would aggressively say that we can apply that to the post-2025 need, but whether or not we would get a fight on that, whether or not we would get credited, because you bring up a good point, remains to be seen. But I think as we stand here now, I would take an aggressive position with that. Does anyone else want to say anything else on that?
I would agree with you.
I mean,
We have a judgment of repose, as long as we maintain our compliance, and under that scenario, we would be technically maintaining our compliance. So I think it's a very valid legal position to take, and probably the one we would want to take.
yeah, but in fair, in What else?
Moving forward, if you have exhausted all avenues of meeting your obligations, you've played around with the numbers for overlay and this and that and yada, 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 what are the ramifications of us then not being able to meet our obligation?
You've met the obligation.
No, I mean like 2025 and above, look, we're moving forward in future years. If you have exhausted all possible avenues to meet your obligation, what are you gonna do then?
It remains to be seen what the fact pattern is gonna be in 2025, and the two major open issues are, what will the number be, because you plan for a number, and then what are the resources in the town? Theoretically, someone could demolish a 400,000 square foot building, and then there's vacant land available in 2025 that wasn't available today. So it's all kind of fact sensitive.
Stranded assets are occurring.
Yeah, as to what the conditions are going to be on the ground in 2025. But the key thing is the number.
And that would come from the legislature? I mean, if it got worked out?
If the legislature, Kathy, if the legislature acted as they did in 1985, then presumably that there would be an administrative body like COA who would set the parameters, the rules, the numbers as they did in the post-85 period until we had this 1999 to 2015, limbo land.
And as much as we complained then, we kind of miss them now.
I know. At least it was a formula.
There was a formula, and there was a place to go. There was a board to go before.
I heard your comment about, the state doesn't care about the consequences of kids to schools. Do we turn to developers and say, since we're losing X amount of dollars in property taxes on that unit, you have to supplement that in some way to make up that difference? Or we really do end up hurting with getting less property taxes and yet maybe need to build a new school?
So the problem, and I'm going to defer, but I'll give you Mike's, is the problem in New Jersey is, and it's a really good question, is that unlike other states, there's no constitutional ability in New Jersey to basically impose impact fees.
Correct.
And they have that in other states to do that very thing.
Right.
You're building this, you have to build this school or contribute so many dollars.
Sewers,
In New Jersey, it's just not happening.
It isn't, and the legislature actually just changed the municipal land use law to make it even more difficult for us to bond for certain things that developers used to pay for, and now they don't. We used to have them bonding for landscaping, for off-site issues, and now all we can do is periphery, all we can do is on-site driveways and roads and things of that nature. We can't bond anymore. We can't force them to give us money to bond for those other things.
So the end result is we all pay more in taxes.
Right, so the answer is the developers have a better lobby with the legislature than we do.
I think you need to put together a list of things that we need to write our legislators about. I mean, there's so much here that I had never even heard of. You've got a whole flock of people who...
And I will tell you, there is a great deal more. I sit on a legislative subcommittee with the State League of Municipalities. We are a lobbying organization that we discuss legislation with state legislators. I sit on the land use legislative subcommittee, and I can tell you that some of the bills that we see, we are a bipartisan or nonpartisan organization. There are members there are members from every political party, and we're all on the same page. We oppose almost everything that comes before us, but the legislature is not listening. The same people get voted in time and time again. So, maybe it's time to do something, to write to that legislature and to pay attention to the bills that are coming out of that legislature. You'd be very surprised if you saw what our legislature was doing.
I'd like to know some specifics on that. Really?
Well, just most recently is just what I mentioned with the change to the municipal land use law. I mean, this is something that that we fought. Another thing that the state did was take away the municipalities' ability to use the franchise taxes that they used to be able to obtain from franchises and use for their own benefit. The state took that and put it into a fund, and we've never gotten it back. There are mayors from around the state that are fighting, and are trying to get legislation to get that money back to municipalities. Off the top of my head, they are always trying to change what the DCA does to make it more stringent. They're imposing more on township clerks, in terms of record keeping. Things like this, they trickle down, they filter down to taxpayers and just make it more expensive to taxpayers.
A little off the topic.
A little bit off the topic, but these are some of the things that
We can get some of this. I'll
the
work
state-
with you, we'll get some of this stuff and
Sure,
and make it
absolutely.
available.
And the state tried to take all the municipalities' affordable housing trust funds. I don't know if that was mentioned at the front end, unsuccessfully, thankfully. So it's not we need a stronger pro-municipality lobby.
Sure.
Last.
I heard, or got the impression, that there were vacancies on the Council of Affordable Housing which were not filled, which rendered it impossible for the council to do its work. Is that true?
That actually did happen. I attended a meeting when Governor Christie was the governor. There was a meeting with the DCA commissioner at the time, Lori Griffa, and the conversation that we had was about taking all of the COA responsibilities and putting them to the DCA. I believe that what you're saying, that's about the time that happened. There were certain positions that weren't being filled because that entity was going to be absorbed by DCA, and that's where all of the confusion happened. And at some point, the court saw what was going on and said, you're not doing anything, we're going to step in right now.
It was probably mentioned earlier, the ultimate 3-3 deadlock on the third iteration of the third round rules.
Right.
When COA had the 3-3 deadlock in October 2014, if I recall correctly.
That wasn't a full COA board.
That was not a full board, but it was enough to come up with a tie and a deadlock. And that's what led.
But it was an even number, which was death.
Yeah, exactly.
Which is death, absolutely.
That's right.
Okay, well,
Any other questions?
one last question? No? Thank you so much.
Thank you.
Really appreciate your information, your expertise, and thank you for being here. Thank you to everyone for coming, and I hope you got the information you were looking for.
Good job.